Now we're going to talk about one of those foundational principles that I had mentioned earlier, one of those foundational principles of our Constitution, and that is federalism, or the sharing of power between state and national governments. Okay, so let's get get a definition out of the way first. Federalism is a system of government that divides power between the national or central governments. It can be called a central government, and the state or regional governments, smaller geographic areas than the national geographic area. So, a system of government that divides power between the national government and the state governments. Both are sovereign in certain areas. Both derive their powers from the people. Neither can abolish the other without the other's consent in a federal system. Neither can change or alter the other without the other's consent. So the national government cannot, decide that it thinks that Mississippi, we've just had enough of it, we want to get rid of it, and can't do that because Mississippi is sovereign in its own right. Um, the national government can't divide Texas up into four different states if it wanted to. It would have to do it with the approval of Texas. So anyway, each has their own powers, and we're going to talk about those powers. But compared to what? If federalism is a system of shared government and shared power, uh, how does it compare to other types of government? I guess that's a good question. Well, let's compare it to Confederation. Remember the Articles of Confederation? That was our first government that we had that was established upon declaring independence. Well, in that type of government, the states are the only sovereign entity. That means the states are the highest power. The states, no one can. There's no higher authority over each of the individual states in a confederation. And in a confederation, the states establish and create the national government and give the national government all the powers that it has. And because they give all those powers, they can take all those powers away. Under a confederation, the states can alter or abolish the national government as they see fit without the approval of the national government. So confederation as compared to federalism. Now, what is a unitary government as compared to federalism? Well, as I mentioned, in federalism, the state and the national governments are both sovereign in their own right. In a confederation, the states are the only sovereign entity. Well, in a unitary system, unitary meaning one, there's only one sovereign entity, and that is the national government. The national government may create, abolish, or alter any of the state uh, entities, any of the state governments. Uh, all power that state governments have is delegated downward from the unitary government. So the unitary government is the only sovereign entity in a unitary system. And this is just a little chart showing the difference between a unitary government and a confederation. And basically, the arrows are what really explain the differences. Um, the arrows represent the flow of decision making and the flow of resources. So the flow of resources go from local to national in the confederation or central. In a unitary form of government, the flow of decisions and resources comes out of the central government and flows downward to the state and local governments. Now, federalism can be really divided up as far as the power arrangements. Who has what power? I guess is the biggest question with federalism. Does the national government have power, and what powers? Well, what powers do the national government have, and what powers do the states have, and then maybe we have to think about what powers both of them have. And so let's look at some terms that help us understand that. First, enumerated powers. Enumerated powers, as I mentioned earlier, are specifically granted to the federal government. Enumerated powers are specifically granted to the federal government. Reserve powers are specifically granted to the states. So basically, we start with the federal government and we say, this is what the federal government can do. These are the enumerated powers. And then after that is taken care of and that is laid out, then we say, okay, these are powers that are reserved to the states. Over and above. It shows the priority of the national government, but it also respects the power of the states. So reserve powers are specifically granted to the states. Concurrent powers are shared jointly by federal and state governments. These are powers that both of them have. Okay, these are powers that both the federal government and the state governments have, and we're going to talk about these different powers. And then prohibited powers are denied to either or both levels of government. Prohibited, obviously, means you can't do it. So if there are prohibited powers, that means the state and or the federal government cannot do certain things, and those are listed in the Constitution. So reserve powers of the national government. These include coining money. Only the national government may produce and manage a currency or a form of payment. You can't have 50 different state currencies out there, 50 different forms of money. That would be confusing and very unworkable. So only the national government may coin money. Only the national government can conduct foreign relations, okay? Make treaties, declare war, all those things. So anything that deals with other nations, only the federal government has that power. You can't have 50 different treaties with Canada or Mexico, with each state, negotiating their own treaties. Uh, Only the national government can regulate interstate commerce. That is commerce between the states, trade between Oklahoma and Texas, or New York and Pennsylvania. Uh, the national government provides for an army and navy. Okay, they they are. It is their job, the national government's job, to ensure protection. Only the national government, and specifically uh, the legislature, the U.S. legislature, can declare war, and only the national government can conduct war. Of course, the states have a national. Each state has a state national guard, but those are not independent. They fall under the auspices of the national government and the U.S. Army and the U.S. Navy, and so only the national government can declare war and can actually conduct the war. Of course, Congress declares the war, and the president, as commander in chief, conducts the war. Only the national government may establish a national court system. Of course, each state, well, always remember this, each state has their own separate court system. Uh, and most cases are heard in those state courts, but only the U.S. government can establish a national court system that crosses state boundaries. And of course, we talked about the necessary and proper clause. Congress can make laws necessary and proper in order to carry out the enumerated powers that they're given. Now, state powers or reserve powers. States manage and dictate election rules. I know most people don't realize this, but when we go vote in the state of Texas is the determining decision maker with regard to how the elections are held, um, what kind of ballots are used, the rules for getting on the ballots, party rules. These are state powers. Also, a reserve power to the state is to ratify amendments to the U.S. Constitution. As we mentioned before, it can be either done by the legislature or state conventions. But no power, excuse me, no amendment can be added to the Constitution without ratification by the states. The states are charged with handling, making laws regarding health, safety, and morals. Most, laws, if you break a law, most laws that you break are state laws. You know, laws against theft, laws against murder, laws against speeding, uh, drinking age laws. All those things are determined by the states. The states have the power to establish local governments. Local governments are not sovereign like the states and the federal government are. The state and the national government. The state and the national government, nobody can alter or abolish them without approval of the state or national government. Though local governments, though, are chartered by the state and only exist because the state lets them exist. And then public schools. Uh, Public schools are established the um, by the states, and historically, the states have determined, and of course the local school districts have determined um, qualifications for teachers, the requirements for graduation, and all of these sorts of things. But of course, recently, since 2001 and George W. Bush's No Child Left Behind policy, uh, that power has been basically taken away by the federal government, the national government, and now we are required to do standardized testing and uh, and things like that. And so the national government is now taken over in a lot of ways, determining the qualifications for graduation. And as I mentioned before, there are also concurrent powers. These are powers that both the state and the national government have. Uh, Tax and borrow money. Both the national government and the state governments, as well as local governments, have the ability to tax you. Of course, if you have a job, you pay federal income tax, which is tax that goes to the national government to help run the government. We also pay state sales tax here in Texas, and local sales tax. Also we pay property taxes too, usually local property taxes. So you're being taxed at all levels of government, but that's how governments function, and that's how governments provide services, is by the money raised through taxation. Now, Texas, uh, and there's good or bad in this. Texas does not have a state income tax. So we pay less overall in taxes than most other states. But of course, if you know anything about Texas government, we provide fewer services, and we provide less money for a lot of uh, services that other states provide more money for, including education and services like that. But Texas does not have a state income tax. Uh, uh, Concurrent powers also include establishing courts. There's a federal court system or a national court system, as well as state courts and local courts. Both can make laws. You have a national legislature and a state legislature, and they both make laws and enforce laws. You have a national executive, president, and all the agencies under him, and then the governor, uh, the executive of Texas, with all the agencies in the executive branch of Texas who enforce the laws. Um, Also, both state and national governments may charter banks and corporations, meaning allow them to exist, give them the right to exist, and both the national government and the state government may use their power of what's called eminent domain, and that is the power to take private property for public purpose with just compensation. So if there's land that the national government or the state government wants to use to, for instance, build a highway, or to expand an easement or a right of way, or whatever, for whatever reason, they can force the owners of that property to sell their property to the government. Now they have to give them just compensation, which means fair market value at least. But it is a huge power that is resented by many landowners who have been a victim of the government's power of eminent domain. And then there are prohibited powers. Okay, prohibited powers. The states, and these are a little bit redundant because they repeat some earlier things that are mentioned as far as the enumerated or reserved powers. States may not enter into treaties with other nations or other states. States may not coin money, and states may not impair obligation of contracts, meaning that if there is a fair legal contract, binding contract between two people or two corporations or a person in a corporation, or whatever, the states cannot just arbitrarily void that contract. National government cannot favor one state over another in commerce, cannot lay duties on exports from states. So the national government can't, like, tax one state and not another, uh, which they don't tax anyway. And they also cannot lay duties or tariffs on exports from the states. Now, the national government can lay duties or taxes or tariffs on imports. Anything coming into the nation, they can place a tariff on it, and they've done that many, many times throughout our history, taxing imports in order to encourage domestic industrial production. But they cannot lay duties on exports from states. Neither can issue bills of attainder. The state or national government can't issue bills of attainder, which are basically legislative punishments or legislative convictions. Uh, you can't. The legislature can't declare somebody guilty and penalize them. That's a bill of attainder. And neither can pass ex post facto laws, which are basically after the fact laws. You can't charge somebody. Well, you can't make a law retroactive and then enforce it retroactively. So you can't arrest somebody for doing something when it wasn't illegal when they did it, but it became illegal later. Some important points in the Constitution with regard to the federalism or and relations among the states. The full faith and credit clause, which I mentioned before, in Article 4, basically judicial decrees and contracts made in one state will be binding and enforceable in another state, in any other state. And this brings up the kind of the modern debate over gay marriage, because basically what states like Texas and many other states have declared through either through legislative acts or through constitutional amendments that marriage is only defined as between a man and a woman, while there are other states in the nation that state that gay people can get married, and that is a perfectly legal right in their state, and that creates a conflict with the full faith and credit clause, which basically says judicial decrees and contracts made in one state will be binding and enforceable in another state. So if a gay couple gets married in Vermont and one of them gets a job transfer to Texas and they move to Texas, the question becomes, are they married in Texas? Well, the state constitution of Texas says no, but the full faith and credit clause says yes. Texas must honor Vermont's judicial decrees and contracts. So, but anyway, that this is a constitutional question that will end up in the Supreme Court for sure. Privileges and immunities clause: citizens of each state are afforded the same rights as citizens of all other states. I mean, you can't have, to a certain extent, you can't have separate laws for people of different states, but you can. There are certain instances that you can treat citizens of states differently, of different states differently, such as in tuition. You can charge them out-of-state tuition, and you can have them, maybe you can force them to be licensed in certain fields like medical field or as lawyers, because Texas law is different in some respects than, say, California law or Colorado law. Extradition clause, Article 4, requires states to extradite or return criminals to states where they have been convicted or to stand trial. If I commit a crime here in Texas and run off to New York, and the people in New York, they arrest me for another crime, and they find out that I'm wanted for a crime here in Texas, if Texas requests my return to Texas to try me in their courts, then New York has to do it. And then interstate compacts are contracts between states with congressional approval. Once again, states can't enter into treaties with each other, but there are certain types of contracts between states that, if Congress approves of it, can be only applied to the 2 or 3 states, or however many states are part of the compact. Now let's take a look at the evolution of federalism. Federalism has changed dramatically over our history as a country, and by that I mean that the balance of power, or between the state and national governments has shifted dramatically. Of course, early on in our nation's history, the states were not really populated. Most businesses were regional, local or regional businesses, and it was there were relatively few major problems that arose that required national government intervention. Uh, so the states had the most power. Now, the first era of federalism from 1789 to 1835 is what we'll call martial federalism, and it's named that because the Chief Justice of the U.S. Supreme Court during this time was John Marshall, and he was a Federalist. And as I said, the states had the most power, and of course, Federalists believed in a strong national government. So he used his power as Chief Justice of the Supreme Court to somewhat shift the balance of power away from the states and more towards the national government. And he did it in such Supreme Court cases as Marbury versus Madison, which we'll talk about more when we talk about the judiciary, McCullough versus Maryland, which is called the National Bank case. Basically, stated that the states cannot tax the national government, and it also set the precedent for the necessary and proper clause. Gibbons versus Ogden, which shifted the power to regulate interstate commerce more to the national government, and then Barron versus Baltimore, which stated that at this point at least, the Bill of Rights only applied to the national government and not to the states. Uh, so Marshall, in these court cases, and just for testing purposes, know which court cases fall under martial federalism, and we will talk more about those cases later in the semester. Uh, Also, you might do a quick Google on all of those cases because it's interesting to know, you know, the stories behind them and the impact they had on our government and legal system. Dual federalism, 1835 to 1863. Roger Taney is the Chief Justice of the Supreme Court, and he is a states' rights Maryland slave owner. So he is going to use his power as Chief Justice to shift power back to the states if possible. And he does this through Supreme Court decisions, including the Dred Scott decision. He believed in a separate and equally powerful levels of government. He felt like under martial federalism that the national government had become too powerful, and so he believed that the states should and federal government should have equal power, therefore to balance them and to check each other equally. Dred Scott decision came out of dual federalism. He in the Dred Scott decision, basically Taney in the Supreme Court ruled that individual slave owners could take their slaves anywhere in the United States that they wanted to, regardless of the laws made by the national government, which outlawed slavery, laws made in the Missouri Compromise of 1820. And the Dred Scott decision was a decision that one of the events that led to the Civil War. Also, the crisis of nullification came up, and this idea during the Taney Court period, Southern states, specifically slave states, began to argue for this power of nullification, or the right to declare national law, a state's right to declare national law unconstitutional. Starting in 1863, which basically is towards the end of the Civil War, up through 1913, we enter an era called transformative federalism. The national government becomes much more involved in certain aspects, including determining how states treat their citizens as far as citizenship rights. You have the Civil War amendments of this time, the 13th Amendment, which outlawed slavery, the 14th Amendment, which guaranteed equal protection of the laws and due process of laws for all citizens, and the 15th Amendment, which attempted to give all men the right to vote, regardless of race, color, or previous condition of servitude. Of course, during this time too, the national government, with the rise of the railroads and the steel companies and these big, huge monopolies, oil and gas companies, the Interstate Commerce Act created the Interstate Commerce Commission, which allowed the national government to regulate these businesses. In the past, the states had basically regulated most all businesses, including the railroads, including the large industries. Yet those industries got so big and so powerful that it became impossible for the states to regulate them properly. And so the national government had to create the Interstate Commerce Act and the Interstate Commerce Commission to begin regulating them. And they began, especially with Teddy Roosevelt, but it even began before that, with antitrust legislation, um, which basically prevented trying to prevent monopolies, trying to prevent corporations from dominating entire industries. From transformative federalism, we go to cooperative federalism, 1913 to 1964, in which we see the government. This is the era in which the government just expands massively due to, you know, events somewhat beyond their control and really necessary in a lot of ways. 16th Amendment provided the national government the power to tax income. And then the 17th Amendment, direct election of senators by the people. Prior to this, the state legislatures elected their U.S. senators. Now the people will elect those senators. The Great Depression uh, hits during this era of cooperative federalism. Of course, Franklin Delano Roosevelt, the President Roosevelt, establishes the New Deal as a way to uh, alleviate the problems of the Great Depression. Of course, the New Deal is a huge expansion of national government power and scope, creating agencies, many different agencies to help put people back to work. And it was and many of those uh, acts of the New Deal were declared unconstitutional and had to be reworked in order to match up with existing law. But just know that it was during the Great Depression and the New Deal that the scope of the government increased dramatically with regard to how it interacted with the states in and and supplying money and grants and to the states in order to put people to work to alleviate the New Deal. World War II, of course, greatly expanded the power of the national government to uh, dictate to all the industries what they would produce and how much they would produce, force them to transition their factories from uh, peacetime production of cars or uh, whatever to tanks and planes to fight to help the war effort. And most of this money uh, that was given to the states to help alleviate the Great Depression were what's called federal grants and aid, which is basically money given to the states saying, "Here, spend this money to build hospitals or build roads, or build schools, or build a dam or whatever." Just the whole point was to put people to work and get money back into the economy. And then starting in 1964 with the election of Lyndon B. Johnson to the presidency, uh, you see an era of centralized federalism where previously in cooperative federalism, the national government attempted to solve specific problems in specific states um, with certain categorical grants that would be determined, by either state and the government working together. Well, in centralized federalism, President Johnson saw some national problems that he wanted to alleviate, and he wanted to address that were a problem in every state. And these included poverty, discrimination, consumer protection, and pollution. And so Lyndon Johnson established his what he called the Great Society, which was an attempt by the centralized government. That's why it's called centralized federalism. The central government or the national government to help you to use their power to solve many of these problems. Uh, and some of the programs that came out of um, the centralized federalism era were Medicare, which is a government funded health care for elderly people, Medicaid, government funded health care for the poor and disabled, and then Head Start, which is a program that provides preschool education for children who, in order to help them be ready to start school, they may come from a disadvantaged background and don't that doesn't provide them the skills and the education necessary in the in the infant and toddler years to prepare them for public school. Gives that This program helps give them a head start and gets them on level with kids from more advantageous backgrounds. Um, then, starting in 1980 with Ronald Reagan elected as president, we enter an era of devolving federalism where they're trying to roll back the power of the central government, the power of the national government in its relations with the states, and rolling back national influence, a shift from categorical grants, which specifically told the states what they could do with national money, to block grants, which are basically big chunks of money, and overall less money than if you add up all the categorical grants, overall less money, but the states in block grants can do with the money and spend the money how they see fit, and giving more administrative power to the states with regard to how to implement programs. And then, starting in 2001 to the present, we are in an era of what I like to call coercive federalism. It's post 9/11, of course, post terrorism, post war on terror, or as we it encompasses the war on terror. You see a dramatic increase in a national security state. It's much like central federalism, except the priorities are not to end poverty, discrimination, and consumer protection. Now the priority and the power of the national government is laser-like focused on security and dictating to the states how they must respond to the security demands of the national government. Um, It includes the USA Patriot Act. Uh, Now, also part of course of federalism is the preemption of state power over educational policy, which we talked a little bit about earlier. That in the past the states had the power to determine, teacher qualifications and dictate what requirements there were for graduating high school and moving up. But now the national government, with No Child Left Behind and their standardized testing, has national government has taken over that. Department of Homeland Security, which was a new government program and the greatest expansion of national power or the bureaucracy since Franklin Roosevelt and the New Deal, basically placed many different agencies that existed prior to 9/11 as independent agencies and put them under the umbrella of one giant agency called the Department of Homeland Security. And then, of course, as far as this security state that we live in now, there have been leaks and stories about the expanded surveillance, which most people argue is unconstitutional and violates the Fourth Amendment protection of unreasonable searches and seizures. Of course, this what I would call illegal expanded surveillance was initially carried about by the Bush administration, but it has been extended and continued by the Obama administration. So, for testing purposes, I would ask you to know the chronological order of those eras of federalism and kind of know what happens within each era. What's the primary important things that define those eras of federalism?